what are the options to formalise agreements about either the care arrangements for your children or the division of your property after you separate? There's a couple of different ways that we can do this. We can formalise the agreement for children in a parenting plan. Now, that's a document that everybody agrees on, what's going to happen with the living arrangements and decision-making, all of those things. And everybody signs off on it. It's not registered with the court and it's not legally binding. But sometimes, even if it's not legally binding, it's the right document, especially if children are going through, usually little kids, in my experience, their needs are going to change. They're going to be different from when they're 6 months old to when they're 6 years old, or from their 12 months to 2 years. We all know that the children's needs are just evolving all the time. So parenting plans are a good way to put down on paper what everybody agrees to, how they're going to care for the child, when they're going to introduce new partners and all sorts of things. And it can be, revisited every year or every couple of years. So that's one option. The other option is for parenting or orders that relate to children is some consent orders. So it's an application that you file with the court and it sets out the orders that you would like the court to make. Now, the wording is going to be different to the parenting plan because a parenting plan can be pretty informal, but the wording for orders has to be quite precise. So those precise orders will be put into an application for consent orders. There's a lot of information that needs to be filed with that, and then the court can have a look at it and see if they're happy to make the orders. For issues relating to property or finances, the options are either consent orders, so again the same, you fill out the forms and you get it all put together with very precise words, and you ask the court to make the orders that you're seeking. Those orders can reflect, the agreement that you've reached relating to your property, to businesses and, to your superannuation, trusts, things like that. The other option for financial agreements is what we call a binding financial agreement. Now, these are under a different part of the Act, and they are a document that I generally don't recommend for young families. It's usually the people that benefit from these the most are people in second marriages or third marriages, and they have had, they're middle-aged, they've got their assets, they want to protect their assets, so that they can leave things to their children and grandchildren and all the rest of it. And they're quite happy to, say, no, if I die or we separate, you keep yours, I keep mine. Again, that's one of those documents. It is very, very precise. The disclosure, the list of assets, the list of liabilities, and then the requirement for each of the parties entering into it to have had legal advice. It's a very strict area of law. Most people will use consent orders for property because it's the option that gives them the benefit of without it, I suppose, is what I'm trying to say. If you just go, we don't need orders, we can do this ourselves and I'll just buy you out and Bob's your uncle. Well, what will happen is that if I buy you out and I don't have a binding financial agreement or some orders stamped by the court, I'm going to have to pay stamp duty on the share that I buy from you. So that's one thing. The second thing is any verbal agreement is not binding. You can't enforce it. You can't run to the court and say, Kelly said she was going to give me $100,000 every year for the next 10 years, but she hasn't. The court can't help you because it's got nothing to enforce, if that makes sense. The other document that people quite often have at the end of a separation, when they're thinking forward and wanting to ensure that their property, if they die, isn't subject to a claim under the Succession Act, they will enter into a deed under the Succession Act. The name of that act in various states is different, but here in New South Wales it's called the Succession Act, and it's a deed or an agreement where you and your ex agree that you've had your property settlement, and if either of you die, you won't make a claim against their estate. And in New South Wales, it gets registered and approved by the Supreme Court. So that way you're really taking every step you can to protect your financial position after you separate. But anyway, so that's it. Parenting plan, consent orders for parenting and property, or a binding financial agreement for property, and the icing on the cake to make sure all of the property stays within where you want it to go is a Succession Act deed. How about that? Anyway, have a good day. Thanks.